And Commissioners. My name is Heather Shirley Smith, and I'm in-house counsel for Duke Energy Carolinas. And with me today are our other corporate counsel, Kamal Robinson and John Burnett. We also have with us our external counsel, Frank Ellerby, Brandon Marzo, and Lynn Anthony. Finally, if it pleases the Commission, I'd like to introduce my paralegal, Monica Smith. We have a lot of stuff to hand out, and you might see her moving around, and I just wanted to explain what we'll be doing there with summaries and exhibits. So thank you.
Thank you. I'm going to go down the list. Walmart is next on my list. Thank you. ORS. Thank you. Vote Solar. Thank you. We want to see if we can possibly get everybody to a mic, because since we're live streaming it, nobody knows what you're saying if you're not in front of a microphone. So, South Carolina NAACP, Coastal Conservation League, and Upstate Forever. Well, let's see, cut that thing on. Let's see.
Is it working now?
Now you are.
Good morning, Mr. Chairman, members of the Commission. My name is Stinson Ferguson, here on behalf of South Carolina NAACP, South Carolina Coastal Conservation League, and Upstate Forever. Here with me today are my co-counsel, David Neal and Goodwin Thompson, both of whom have been admitted pro hac vice to this matter.
Thank you. Thank you. Sierra Club.
Good morning, Mr. Chairman, Commissioners. Robert Guild for Sierra Club. With me today is Bridget Lee, the senior attorney with the Sierra Club's environmental law program. Good morning.
Thank you. South Carolina Energy Users.
Mr. Chairman, I'm Scott Elliott. I represent the energy users in this docket. Thank you.
Thank you, sir. Okay. I missed anybody? Okay. Okay. Who's not here? Oh. Okay. Yeah, Mr. Dharma Wardna is not here. He's pro se. Okay. Are there any preliminary matters that need to come before the Commission before we get rolling? Okay. Before we start, I just want to remind everybody that when you testify and when you cross, please be focused. We got a lot of stuff to get through, and I would encourage all of you to, all of you attorneys, to talk and coordinate. If your point's been made by another, feel free to move on. If your point has already been made and you decide to stay with it, please don't be offended if I help you move on. A lot of you have been in hearings with me before, so I'll save any comments about anybody's love of having a microphone later if I need to. So, with that, we will ask Duke Energy to present your case.
Thank you, Mr. Chairman. At this time, we'd like to call Kojo Garti-Tago and Kim Smith to the stand. Have they been sworn in? Okay, got it. Thanks.
Ms. Smith, Ms. Wheat says it might be better if you do your questioning from over here so they don't turn around to talk to you. so they can be facing this way? Does that work for you? Or
that absolutely works.
As long as they can maintain this way, we
Sure.
can do it from there, but whichever.
Sure, if I have any redirect, I might do it from here since I've got my material here, but I'm happy to read them in from over here.
Not yet. Punch.
This one on, okay.
There you go.
All right,
You're
we're
on.
ready to go.
You're good.
All right. Mr. Garchi-Tago, could you please state your full name and business address?
My full name is Kojo Garchi-Tago. Business address 40 West Broad Street, Greenville, South Carolina, 29601.
Thank you. By whom are you employed and in what capacity?
I am employed by Duke Energy Corporation as State President, South Carolina.
Okay. And did you cause to be pre-filed in this docket direct testimony consisting of 40 pages?
I did.
And do you have any changes or corrections to your direct testimony?
No, ma'am.
And if I asked you the same questions today, would your answers be the same?
They would.
Okay. And Mr. Garchi-Tago, did you cause to be pre-filed in this docket rebuttal testimony consisting of 19 pages?
I did.
And do you have any changes or corrections to that rebuttal testimony?
No, ma'am.
And if I asked you the same questions today, would your answers be the same?
They would.
Mr. Chairman, at this time, I move that the pre-filed direct testimony and the rebuttal testimony of Mr. Garchi-Tago be copied into the record as if given orally from the stand.
Mr. Garchi-Tago's pre-filed direct testimony and what was the other rebuttal?
Yes, sir.
Rebuttal testimony will be entered into the record as though given orally from the stand.
All right, thank you. Ms. Smith, please state your full name and business address.
Kim Hamrick Smith, 550 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
Duke Energy Carolinas is a Director of Rates and Regulatory.
And did you cause to be pre-filed in this docket direct testimony consisting of 43 pages and Smith Exhibits 1 through 3 consisting of 33 pages?
Yes, I did.
Do you have any changes to that testimony or exhibits?
No, I do not.
Did you also cause to be pre-filed in this docket supplemental direct testimony consisting of 10 pages and supplemental Exhibit 1 consisting of 1 page and updated Smith Exhibit 2 consisting of 3 pages?
Yes, I did.
Okay. And do you have any changes or correction to that testimony?
No, I do not.
And if I asked you the same questions today, would your answers be the same?
Yes, they would.
Okay. Rounding out here.
Okay.
Did you also cause to be pre-filed in this docket rebuttal testimony consisting of 25 pages and Smith rebuttal exhibits 1 through 3 consisting of 33 pages?
Yes.
And do you have any changes or corrections to that rebuttal testimony?
No, I do not.
And if I asked you the questions today, would your answers be the same?
Yes, they would.
Okay. Mr. Chairman, at this time, I move that the pre-filed direct testimony, supplemental direct, and rebuttal testimony of Ms. Smith, as well as her exhibits, be copied into the record as if given orally from the stand.
Okay, Ms. Kim Smith's pre-filed direct testimony, supplemental direct testimony, and rebuttal testimony will be entered into the record as though given orally from the stand. Her exhibits will be entered as hearing exhibit number 10.
Thank you. And we have passed out to the Commission copies of summaries for Mr. Garchi-Tago and Ms. Smith, and you both have summaries you'd like to deliver for the Commission, is that correct?
Yes.
And at this time, we do have extra copies of that summary. I'd ask Ms. Monica to pass those out to anybody who'd like to see them. So just one after the other, just for the efficiency of time. Mr. Garchi-Tago, would you like to deliver your summary of your testimony, followed by Ms. Smith?
We want to make sure y'all get close to the mic so you're not picking up. Got to speak into it so everybody can hear and we can pick it up on live stream. Thank you.
Good morning, Mr. Chairman and Commissioners. We're here today seeking a change in rates to reflect our continued investment in the state of South Carolina and the cost to provide safe, reliable, cost-effective, and increasingly clean electricity to our customers. As I describe in my direct testimony, Duke Energy Carolinas has invested heavily in cleaner burning natural gas fueled plants, including the W.S. Lee Combined Cycle Natural Gas Plant in Anderson County. Natural gas fuel plants like the Lee CC emit carbon dioxide at about half the rate and nitrogen and sulfur oxide emissions at a fraction of the rate of the coal plants they replace. The The company has also invested an additional $152 million in the development of 2 large solar facilities, providing additional carbon-free renewable generation to our customers. Duke Energy Carolinas is also requesting recovery of project development costs related to the Lee Nuclear Project. The company has also started the process to ensure compliance with state and federal regulations requiring the company to address coal ash basin closures at plants which have served or are continuing to serve the customers in South Carolina. We have worked hard to reduce our impact on the environment by retiring older, less efficient coal plants across the Carolinas and have retired all of our coal plants in South Carolina. Duke Energy recycled more than 78% of coal combustion byproducts in 2017, and that includes Duke Energy Carolinas recycling or beneficially reusing the ash that is produced at our coal-fired plants. We have retired half of the coal-fired plants owned by Duke Energy in the Carolinas. And now we are closing all ash basins across the Carolinas in compliance with new sweeping state and federal laws and regulations as part of Duke Energy's commitment to provide increasingly reliable, cleaner power to customers at reasonable rates. Like any waste, we must ensure that coal ash is managed responsibly. Additionally, we are planning for the future by starting the process of rolling out a new customer information system to ensure the best customer service possible by completing the deployment of AMI smart meters within the Duke Energy Carolinas territory, and based on customer feedback, offering fee-free payment programs for residential customers for all methods of payment. As a result of these investments and other costs, the company is requesting amortization of regulatory assets related to environmental compliance costs, the Lee CC plant, the Carolinas West Primary Control Distribution Center, advanced metering infrastructure, and customer information system. We believe it is necessary to make these investments to better serve our customers. We know that these smart investments in technology, infrastructure, and environmental protection will help connect millions of our customers to the energy future they expect. In my rebuttal testimony, I addressed major concerns that were raised at the time by the Office of Regulatory Staff and other interveners. The first issue that I address is the ORS's suggestion that South Carolina customers should not have to pay for costs which the company incurred to comply with North Carolina's Coal Ash Management Act, also known as CAMA. Historically, the company's generation, fuel, and associated costs are allocated between South Carolina and North Carolina. The ORS incorrectly suggests that CAMA imposes additional expenses on South Carolina. To the contrary, the coal ash beneficiation requirements in CAMA will result in South Carolina customers receiving millions of dollars in net savings. The second issue concerns some fundamental disagreements on the company's proposed return on equity and deferred costs. The ORS proposes to stretch certain deferred costs over an extended period without recognizing the cost to finance the balances during that period. Their proposal ignores the way the company finances its carrying costs, departs from good regulatory practice, and arbitrarily attempts to lower the company's cost of capital. We have shown that the company's proposed return on equity is in line with other ROEs determined by other regulatory commissions in the Southeast. Finally, I addressed the reactions to the company's proposal of a cost-based facilities charge, which is allocated to each customer. We do not contest the basic facilities charge proposed in ORS witness Seaman Wynn's rebuttal testimony of an $11.96 basic facilities charge for residential non-time-of-use customers, $13.09 for residential time-of-use customers, and $11.70 for small general service customers, and to put the remaining revenue requirement ultimately determined by the Commission in the variable component of such rates. In ongoing conversations with customers, in listening to testimony at public hearings, and after reading relevant testimony and comments filed by interveners and customers, we continue to hear the concerns of our customers. The company realizes that regardless of how justified a rate case may be, there is no good time to raise customer rates. The company wants to help customers understand their energy use empower them to save money on their electric bill, and provide programs for every type of energy user and budget. This concludes the summary of my direct and rebuttal testimony.
Good morning, Mr. Chairman, Commissioners. I filed direct, supplemental direct, and rebuttal testimonies in this case. My direct testimony discusses the results of Duke Energy Carolina's operations under presence rates on the basis of an adjusted historical test year using the 12-month period ending December 31st, 2017, and supports the pro forma adjustments to the test period. My direct testimony also explains the accounting request the company is making regarding deferrals of costs. In addition, my direct testimony discusses the company's request for approval of an excess deferred income tax EDIT rider. My testimony explains the EDIT rider and the 5 categories of benefits it contains for customers. In my supplemental direct testimony, I present updates to certain accounting and pro forma adjustments and present additional adjustments to the company's cost of service. I also present updates to the company's proposed EDIT rider. In my rebuttal testimony, I address several accounting and rate-making adjustments proposed by the Office of Regulatory Staff. I address certain accounting adjustments for which we agree with the ORS or do not oppose their adjustments. I also address ORS adjustments that the company opposes. In particular, I oppose the ORS recommendation that the company be disallowed a return on the incremental costs which the company has deferred in a regulatory asset on its books during the deferral period. I also oppose the disallowance proposed by ORS, which would deny the company its carrying costs during the amortization period for the Lee Nuclear Project development cost and for the portion of the other regulatory assets that the ORS has identified as related to operating expenses, as well as unnecessarily long recovery periods for deferred costs recommended by the ORS. If the Commission accepts these proposals, DEC will not be able to fully recover its prudently incurred costs. Debt and equity investors require return on the cash they have provided to the company, both during the deferral period as well as during the amortization period. To disallow recovery of these costs would be to disallow prudently incurred costs, and no one suggests these costs weren't prudently incurred or that they were not in fact incurred. My testimony further explains that the amortization periods recommended by ORS witness Morgan are unnecessarily long for the deferrals requested for Carolina's West Control Center, Lee Combined Cycle, and the South Carolina AMI. Since the ORS has recommended to disallow the return during the amortization period, the longer the amortization period exuberates the disallowance. The company opposes these recommendations. The ORS's logic is contradictory as it does not support a return because the costs were not originally classified as capital, but then the ORS treats them like capital by proposing such lengthy amortization periods. My rebuttal testimony also addresses ORS proposed adjustments not related to deferrals that the company opposes. The company vigorously opposes the ORS recommendation to disallow certain coal ash-related costs as explained by company witnesses Karen and Wright in the rebuttal testimony. I also explain in my rebuttal testimony that although the company does not oppose the ORS recommendation to use an 8-year average expense level for storm restoration costs, we do oppose the ORS removing the inflation impact to storm costs. The company's adjustment is more reasonable as it adjusts each storm cost year included in the average to be comparable to the test year on an inflated adjusted basis, which is appropriate as costs associated with storm restorations have increased significantly in the last 10 years. The company objects to ORS witness Gobby Smith's exclusion of annualized test period O&M non-labor expenses. The requested adjustment is very similar to the customer growth adjustment, which the ORS has accepted. Both adjustments annualize impacts, one for customer growth and one for inflation, and both are appropriate to include. Company witness Metzler also discusses this by providing an overview that Duke Energy Carolinas does not agree with ORS witness Smith's recommendation to remove 50% of DEC's long and short-term incentive program cost. ORS witness Smith further recommends to disallow certain rate case expenses due to alleged insufficient documentation to support the cost, specifically legal expenses provided by outside counsel and billed via an e-billing system. The ORS has essentially asserted that only a paper invoice will suffice. Duke has utilized an e-billing system for several years, as do many large companies, for administrative efficiency. DEC has offered to provide ORS additional information such as affidavits from our vendors, but we have not yet heard back. These expenses were prudently incurred and no justifiable reason for disallowance has been given. The company also requested costs related to the Customer Connect project. ORS witness Payne recommend removing DEC's proposed increase to O&M as not known and measurable. This is not true, as the costs are based on amounts specified in signed contracts. To allow the company no level of O&M or solely the amount in the test period for Customer Connect would be unreasonable. At a minimum, the company's actual O&M of 2018 should be allowed. However, DEC believes its proposed amount is reasonable and should be allowed. Removing the operating expenses needed to implement the project is the same as denying DEC the opportunity to recover those costs for a new billing system, which no one has opposed. An alternative that the company would support is for the Commission to approve a continuation of the deferral of the incremental operating expenses incurred related to the Customer Connect project, including a carrying charge on the incurred cost until the company's next general rate case. In addition to these recommendations, I also oppose ORS witness Smith's recommendation to remove certain expenses from O&M. Duke Energy Carolinas disagrees with the removal of the lineman rodeo cost, employee incentives, safety and service and safety awards, and any cost to recognize and reward the company's employees who serve our customers. The company further disagrees with the removal of organizational dues in support of business, economic development, and the communities we serve. Finally, the company disagrees with the ORS removal of costs shared between North Carolina and South Carolina. The ORS focuses on what costs South Carolina customers should not pay, but ignores the effect of that logic on what costs South Carolinas should bear under that same theory. This concludes the summary of my pre-filed testimony.
Thank you. Thank you. Mr. Chairman and members of the Commission, at this time, the witnesses are available for questions.
Thank you. Okay, we're just going to use my list, but I've got vote solar. You have any? And if you don't have cross, you can just say no cross. If you do, step up to the microphone.
Good morning, Mr. Chairman and members of the Commission and the hearing officer. My name is Thad Cully, Regional Director and Regulatory Counsel for Vote Solar. First, want to say thank you for giving me the privilege of appearing before you as Parag Vice. I do appreciate that, and will do my best not to wear out my welcome. So, thank you.
Good plan.
So, I have pre-circulated some hearing exhibits that I will reference as I go through, and will direct my questions specifically to Mr. Garchitego. So,
Mr. Cully, if you don't mind, can the witness have just a moment or two to look at the document?
Oh, absolutely.
I don't want to slow us down, but I'd like for him to be able to look through it just real quickly.
Absolutely. Thank you. Thank you. So first, would it be accurate to state that your position in your pre-filed direct testimony was that in proposing a $28 BFC, you were simply going where the numbers in the cost of service study led you?
That's correct.
And to be clear, with the letter notice that the company submitted yesterday, there's nothing in that letter that would change the company's math on reaching that potential or theoretical BFC of $28. Is that correct?
That's correct.
And would you agree that a BFC of $11.96 is within the, we'll use a term of art, general ballpark of what the witness for Vote Solar, Mr. Barnes, identified as his maximum theoretical BFC?
That is correct.
But you do recognize that despite the proximity of those numbers, there remain significant differences between parties on the method used to get there.
Yes, I agree with that.
Would you agree with me that a change in the cost of service methodology is not a trivial matter?
I agree with that.
And based on your experience as a regulatory lawyer and working with the utility, it would not be surprising for the commission to weigh in on the merits of a change in cost of service methodology, would it?
It would not.
Make sure you get close to that mic because I can't hear you. I heard you that time, but other times you didn't.
And would you also agree that rate making is not an objective science? I can maybe state another way that there are subjective choices made along the way that influence in a material way where you land.
I agree with that.
And with all that said, is the company's objective to pursue approval in future cases of a BFC that reaches the theoretical maximum it could hit?
I don't think we've made that decision.
Okay. Well, would you agree with me that the company's choice of a cost of service method in this case kind of determined the upward limit of what the company could seek for a BFC?
Based on the cost of service study, yes.
And if the commission were to reject this new approach, the minimum system approach, that would in fact reject that higher upward limit.
Based on that cost of service study, yes.
Okay, now at this time I'd like to turn to the first document I handed out, and I will put this on, I believe we call this the ELMO, is that correct?
That's correct.
We'll give this a second to see if it can. Okay, but okay, there we go. And I would ask that this be marked for identification as a hearing exhibit. Would this be number 1?
No, this will be hearing exhibit number 11.
Mr. Garditego, do you recognize this docket and case number as being a Duke Energy Carolinas rate case from the year 2011?
That's what the document shows, yes.
And this is the testimony of Jeffrey Bailey, who was a rate design witness, is that correct?
That's what the document shows.
Now, if you could turn for me, please, to the second page. And there's Bates numbering there, so it's page number 2. And you will see. Now, if you look on lines 7 through 8, do you see that the witness says that, quote, the cost of service study supports a BFC for residential service of approximately $13.67 per customer per month?
I see that.
Okay, thank you. And could you now look at lines 17 through 21, where the witness says, we propose to increase the BFCs to better reflect the cost to serve these customer groups. In most cases, we propose to increase the charges by approximately 1/3 of the difference between the current BFCs and those charges determined in the cost of service study indicated above. Based on this methodology, we propose the following BFCs: rate schedule RS and RE, $8.72. And I'll stop there. Do you see that?
I do.
So would you agree in this 2011 case, the cost of service study appears to support a maximum or theoretical BFC of $13.67?
That's what the document says.
And that's where the numbers would lead you if you were to seek full cost recovery of those customer unit costs at that time.
Based on that cost of service study, yes.
Okay. And now if we could please turn to the very back of this document. And it's the Bates number 4. And this should say in the upper left-hand quarter, docket number 2013-59E. And do you recognize that as being the company's 2013 rate case?
Well, that's what the document says.
Okay, thank you. And do you see the columns titled Theoretical BFC, Calculated BFC, and Current BFC?
I do.
And do you see in the residential row that the theoretical BFC for this case was $13.87?
I do.
And for the current BFC, that would be $7.29. Is that correct?
That's correct.
And would you accept that the difference between this theoretical and actual is $6.58? Maybe subject to check.
Subject to check. That looks like the right math.
And on the column, this says the increase for the residential row, that is $2.19. Is that correct?
That's correct.
And is that consistent with the 30% increase the company had pursued in 2011?
That's correct.
Okay. Now, in your rebuttal testimony, you state that Mr. Piero's recommendation was to take about 50% of that gap revenue using the minimum system method. Is that correct?
That's correct.
Okay. So would you agree with me at least that in a couple ways the company's practice now is departing from the past practice?
Yes.
Okay.
Well, the practice in the case we just cited, yes.
Yes, thank you. So I think at this time I'm going to skip ahead and go to a second hearing exhibit, which I would identify here and ask that it be marked for identification. I believe that will be hearing exhibit 12 now.
It will be hearing exhibit number 12.
Mr. Arteaga, do you have that in front of you?
I do.
Now, if you could look at page 3, this is a data request to the company from ORS, and it's ORS rates request 13-4. And do you see where there's a table on that page titled Basic Facilities Charge Using the Basic Customer Method?
Yes.
And can you read for me the amount of the theoretical BFC for the row residential, parenthetical RS?
$16.02.
And you might agree with me, parties might challenge whether or not that number is accurate. Interveners tend to do that, right?
Yes, I wouldn't be surprised.
Now, did you take part in the decision to approve this specific methodology for the case, the minimum system versus the basic customer method?
I did.
And in making that choice, were you given a menu of options? Say, door number 1 leads to the basic customer method and a BFC of $16. Door number 2 leads to $28.
Well, not that specific in terms of what the, but it was a choice of cost of service study from the start of preparing for the case. And I certainly had the understanding that the method that was selected for this case would result in a higher cost than the method that had been selected in previous cases.
Sure. And based on this data response, do you agree that difference would be about $12?
Yes.
And are you aware of a 1991 order by this commission, order number 91-1022, that rejected the use of the minimum system method for Duke Power?
I am aware of a commission decision that rejected that, yes.
And could you confirm with me that this current case represents the first case since 1991 before this commission where this company or any predecessors attempted to use the minimum system? Are you able to confirm that?
I haven't been involved in all the previous rate cases, but that's my understanding, yes.
Okay, Well, let's return to this exhibit, and this is really my last couple of questions. Might involve a little bit of math, so I'll go gently.
But before you move on, I would say, you know, the fact that a commission decides something years ago doesn't mean that based on changes in policy or changes in circumstances, they couldn't take a different position. The methodology we proposed in this case has been approved by other commissions, including fairly recently by the North Carolina Commission.
Okay. And are you aware there's some disagreement between the North Carolina Commission, I'm thinking particularly of Commissioner Clodfelter, who filed a dissent in the most recent cases, questioning the continued applicability or wisdom of using the minimum system?
I'm aware he filed a dissent in the case, yes. But the majority voted for it.
Right. That's right. Dissents are rarely quoted by the winners. That's right. So let's go back to this exhibit where the company calculated the theoretical BFC 1602. Would you agree the difference between the theoretical maximum BFC and the current BFC is about $7.73?
Which exhibit are you on now?
Oh, I'm sorry. This is what is still up on the Elmo here. Hearing Exhibit 12 on page 3.
Okay. I'm with you now.
Okay, so subject to check, would you accept that the difference, the gap between the actual and the theoretical is 773?
Yes.
Okay, and would you accept, subject to check, that 30% of that gap, 773, would result in a number amount of $2.32?
Subject to check, yes.
Okay, thank you. So let's assume the commission rejects the minimum system method and accepted 1602 as the theoretical BFC in this case. If the commission forced the company to follow its prior practice, would you agree the BFC increase would go from 829 to 1061?
That math would work, yes, but it doesn't mean that if we had used that method, that's what we would have proposed in this case.
I really do appreciate your answers, and thank you very much.
Thank you.
Mr. Chairman, at this time, I'd like to move for admission of these hearing exhibits.
They're already, wait, hang on. Okay. So yes, they are accepted and entered properly.
Thank you.
Okay. NAACP Coastal Conservation League, Upstate Forever.
Good morning, Mr. Chairman, Commissioners. I'm David Neal on behalf of South Carolina NAACP Coastal Conservation League and Upstate Forever. Good morning, Mr. Garde-Tago. My questions will be for you. And we're going to stick for a minute on this question of the basic facilities charge. As given your role with the company, you agree that rates approved by this commission have to be just and reasonable and not unduly discriminatory, isn't that right?
I agree with that.
And you'd also agree that the burden is on your company to justify any proposed rate adjustments.
I agree with that.
And just to make sure we're clear, the only justification that the company has provided for its proposed increase in the basic facilities charge comes from the use of the minimum system method that you were just discussing with Mr. Culley in the cost of service study. Isn't that right?
Yes, and the general principle that customers should bear the costs that we believe are incurred to make electricity available to them.
Now, I understand that's your company's position, but just to be clear, it is the use of the minimum system methodology that that came up with that figure.
Correct.
Now, you also testified in your direct that with the proposed rate adjustments in this case, as initially proposed, customers would pay, and I'm quoting from page 26 of your direct, rates below the national average. Do you recall that testimony?
Yes.
And now you recognize, however, that the basic facilities charge that your company initially proposed would have been well and above, much higher than the national average. Isn't that right?
Well, that statement you quoted or referred to refers to the overall rates that the company would be charging customers if its requests were approved, not just the basic.
That's right. But I'm asking that you are aware that segmenting out the basic facilities charge as a component of a residential customer's bill, that the initially proposed basic facilities charge would have been the highest in the country for an investor-owned utility.
I've seen that in some of the press that your organization has put out, but I have not done a complete survey of every investor-owned utility.
Have you?
I am aware that there are cooperatives in this state that charge close to that. There are municipalities, I'm sure, around not only the state but elsewhere that may charge as much as that.
But you're not proposing that Duke Energy Carolinas will become a member-owned cooperative?
I'm not, but their customers use electricity too. So I'm not sure what the point of that is.
Well, the point is you believe it's relevant information for this commission to consider national averages. And Mr. Barnes, in his testimony for Vote Solar, indicated that the national average allowed for increases in basic facilities charge approved by public utility commissions around the country for investor-owned utilities is about a 13.5% increase. Did you read his testimony to that effect?
I did.
And that would mean that the new proposed basic facilities charge as of yesterday, this $11.96 increase, which is a 44% increase, would in percentage terms be 3 times higher than recently approved under the national average.
That's the way the math works, yes.
Okay, moving along. In your rebuttal testimony, you said that an issue of great concern to you is the apparent misunderstanding regarding the company's basic facilities charge. This was on page 9 of your rebuttal.
Yes.
And continuing, you testified that parties seem to assume that this change in the basic facilities charge is additive. Do you recall that?
Yes.
Okay. And did you also read, in preparation for this hearing, the testimony of Mr. Jonathan Wallach?
I think I read a summary of it, yes.
Okay. And again, either I could, if I could either, oh, it's on, good. I could turn your attention to page 24 of Mr. Wallach's testimony. Do you have that?
Did counsel bring a copy of that for the witness?
Yes, if he has it, that's great. I'm happy to bring a copy.
I do not have it.
I may have heard. Just directing your attention to page 24, lines 20 through 24, do you see that Mr. Wallach testified, pardon me, with a fixed amount of revenue requirements to be recovered from the residential class, the higher the residential BFC, the lower the volumetric energy rate, and vice versa?
I see that, yes.
So you would agree that Mr. Wallach understands that there's a relationship between the BFC and the volumetric rate, and that it's not just additive. Isn't that right?
That's right.
Can you point to something in something else in Mr. Wallach's or Mr. Howitt's testimony that would indicate that they assume that the change is additive?
Not sitting here right now.
All right, I can skip some things that were already covered. Now, on page 24 of your direct testimony, you cited a resolution adopted by the National Association of State Utility Consumer Advocates, or NASUCA, in support of the company's proposal to eliminate credit card fees. Do you recall that?
Yes.
And I take it that you would not have submitted a resolution from NASUCA in support of your proposal if you didn't generally think that NASUCA is a reputable and credible organization. Isn't that right?
That's correct.
And you would agree that one of the goals of the National Association of State Utility Consumer Advocates is to ensure access to least cost electric utility services for customers.
I'd agree with that. But to be clear, I'm not, by citing it, I'm not suggesting I agree with everything NASUCA says.
Sure, but were you aware that NASUCA also adopted a resolution against electric utility efforts to increase fixed charges?
I'm not aware of that.
If I could at this time have an exhibit marked, I assume we're at 13.
Do you have one for the
Oh, yes.
commissioners?
Sorry. My apologies.
We might mark it then.
Apologies.
Be marked as number 13.
Apologies. Pro Hoc Vice coming through.
Hang on. Got one. Okay.
Okay.
Thank you.
Mr. Garte-Tago, I've handed out what's been marked as hearing exhibit 13, which is the NASUCA customer charge resolution from 2015. It's titled 2015-1, opposing gas and electric utility efforts to increase delivery service customer charges. Now, again, drawing your attention to what's been marked as hearing exhibit 13, I take it that you haven't previously read this resolution before?
I have not.
To try to speed things along, I highlighted some provisions. If you turn to the very last page, I think what should be the final highlighted section, the be it further resolved. You see where it reads, be it further resolved that NASUCA urges state public service commissions to reject gas and electric utility rate design proposals that seek to substantially increase the percentage of revenues recovered through the flat monthly customer charges on residential customer utility bills, proposals that disproportionately and inequitably increase the rates of low-usage customers, a group that often includes low-income, elderly, and minority customers throughout the United States. Do you see that?
I do.
Okay. And to speed things along, I won't have you read through the other highlighted portions. But you recognize that NASUCA's position is consistent with the position of my clients in this case.
I do.
All right. In this docket, Mr. Garte-Tago, Duke Energy Carolinas has not made any commitment of shareholder funds or otherwise to benefit low-income ratepayers that would maybe mitigate impacts from its proposed rate adjustments. Is that right?
We have not.
Can you commit to the company doing so?
No, I cannot. But I will assure you, we provide funding. We'll share the warmth. That funding comes from both customers, our employees. Our foundation puts money into that as well. So that's available and often goes to lower income customers who have challenges paying their bills.
Thank you. I have no further questions. Oh, but this time I would move to admit hearing exhibit 13.
Hearing exhibit 13 will be admitted into the record. Okay, Sierra Club.
Good morning, Mr. Chairman, Commissioners, Hearing Officer Dong, and Ms. Wheat. My name is Bridget Lee from Sierra Club. Good morning, Mr. Gardy-Tygo and Ms. Smith. I believe most of my questions will be directed to you, Mr. Gardy-Tygo. I'm going to switch gears a little bit from the previous questioners. Your testimony addressed impacts of the company's requested rate adjustment to customers, and specifically you explained the impact to the typical residential customer. Is that right?
Yes.
Okay. Of those impacts, the requested increase in rates, do you know what percentage is attributable to the coal ash cleanup costs that are requested for recovery?
Not sitting here now, but Ms. Smith might be able to help with that.
Smith?
I do not have the percentage increase, but it is one of the larger increases.
Okay, thank you. Is it more than a half, do you know?
I would say more like a fourth.
Between a third and a half, okay.
Yes.
And Mr. Gardy-Tygo, you've also testified that the company expects to continue to invest significant amounts related to coal ash compliance after the December 2018 cutoff in this case. Is that right?
That's correct.
And of those future costs, has the company estimated what the total might be?
I believe Mr. Karen can answer that. We do have some estimates.
Okay. And do you know, or would Mr. Karen be the witness to ask if there's an estimate about how long coal ash pond closure and groundwater contamination might take?
Mr. Karen.
Okay.
Probably answer that.
Sorry, just skipping these questions that I can ask Mr. Karen instead. And I have a few more, but if you want to defer these to Mr. Karen, just let me know. So the current estimates for the cleanup of coal ash, is it right that those are based on the assumption that many of the company's ponds will be capped in place?
I know some will be capped in place.
Okay.
I don't know what you mean by many, but yes.
Some are being excavated.
Some are being excavated.
Okay, sure.
Absolutely.
There's a mix there.
There's a mix.
Okay. And so if the EPA or the North Carolina Department of Environmental Quality or a court required excavation of all the ponds, is it your understanding that the total cost would be higher than what the estimate now is?
Absolutely.
Okay.
I will say in South Carolina, through a consent agreement with the Department of Health and Environmental Control, we have and are excavating the two basins we have in South Carolina.
Thank you. And in your testimony, you mentioned that the company is not seeking recovery of any fines or penalties incurred related to coal ash management. Is that correct?
Yes.
But is the company seeking costs related to the cleanup of the Dan River spill, aside from fines?
No.
Okay. How about with respect to the closure of the ponds at Dan River?
Yes, we are.
Okay. And you've testified that the company has followed industry practices in storing its coal ash and has done so consistent with regulations, correct?
Correct.
Okay. Are you familiar with the North Carolina 2L groundwater standards that took effect in 1979?
No, ma'am.
Okay. As a former senior VP for state and federal regulatory legal support, are you familiar with the Clean Water Act?
Yes, I am.
And its implementing regulations?
I know they haven't.
In a general sense, sure.
Yes, in a general sense.
Okay. Are you aware that in 2015, the company pled guilty to violations of the Clean Water Act and its regulations as part of a criminal investigation following the Dan River spill?
I am aware of that, yes.
Okay. And were the violations the company admitted to, were those limited to the Dan River spill, or did they involve other mismanagement at other coal ash sites?
They involved a couple other sites, yes.
Okay.
I wouldn't call it mismanagement, but they involved incidents at other sites.
So you say you wouldn't call it mismanagement, but isn't it right that the company pled guilty to criminal negligence?
We did.
And so is criminal negligence not mismanagement?
Well, as you know, the Clean Water Act is a strict liability statute, and there's a joint statement of facts that goes with the plea, and I would refer you to that.
Sure, thanks. Would it be fair to say, given that joint statement of facts, that at least for Dan River and the other coal ash sites that are
part of that federal case, the company didn't act consistent with regulations 100% of the time.
With respect to those incidences, yes.
Okay, that's all I have. Thank you.
Thank you, Ms. Lee. South Carolina energy users.
If I may, a few questions for Ms. Smith. Wouldn't want you to feel left out.
Yeah, I don't want to feel left out.
Ms. Smith, I'd like you to help me understand just briefly what AFUDC is.
That is the interest that's accrued during the construction of a plant to reflect the time value of money, because we are not recovering those costs from our customers at that time.
And so if I were led to understand by Bill Sandifer, who's the chairman of the LCI committee, that AFUDC is essentially financing cost, would that be a fair generalization?
Yes.
All right. Now, you are aware that the company is seeking recovery of $248 million in AFUDC in this case for the Lee nuclear plant.
Yes, I am.
And if I showed you page 27 from Mr. Fallon's testimony. Can I get a little help up here? I've forgotten since November how to work this thing.
Did you bring a copy for the witness?
Well, I tell you what I can do. I can show her page 27.
Do you have an entire copy of Mr. Fallon's testimony so she can read it for context?
Can I make that? Okay, gotcha. Thank you. You will see a chart there, Ms. Smith, of a cost category. I think you would recognize it. I'll note that on lines 1 and 2, Mr. Fallon says, company witness Kim H. Smith describes the rate treatment, including the proposed amortization schedule, in her direct testimony filed in this case. Do you see that line of testimony in this?
Yes, I do. And I would also like to correct. I think you asked me if the company was asking to recover $248 million of AFUDC, but the South Carolina share is only around 24%.
Good. Thank you. And you are reading my mind, but for these purposes, system-wide, that Mr. Fallon's number is correct, 248, correct?
Yes, that's correct.
And in making your calculations in your testimony, you used the 248 number and then reduced it to 24%
yes.
South Carolina.
Yes.
Good, thanks. And you understand that because you testify in your testimony that there have been at least a couple of orders of this commission that address the cost recovery for Lee Nuclear, correct?
Yes.
And one of those orders arose in docket 2011-20E, which you cite in your testimony. Is that correct?
Yes.
All right. And you understand that the commission in order number 2011-454, arising out of docket number 2011-20-E, capped recovery of certain Lee nuclear construction costs. Do you recall that from your
I believe he's asking for a legal conclusion from the witness, and she's testified she's not an attorney.
Well, I think she's testified to just a factual statement from this order. And I'm happy just to show her the provision of the order that sets out the cap.
And what page of my testimony are you referring to?
Well, you cite on page 26 of your testimony the this docket. Excuse me. You cite
My direct testimony?
yes, ma'am. I'm sorry, direct. I've got it. I'm sorry. You cite on page 19. If you'll look at line 8, please.
Okay.
Now, having refreshed your recollection from your testimony, do you recall having read the order in that docket?
From the docket 2011-20-E, I cannot say that I read the whole order, no.
All right. Let me draw your attention to page 17 of the order, and there's a paragraph 3. And the order reads, the company must incur only those costs absolutely necessary to keep the Lee nuclear project available as an option in the 2021 timeframe. The prudency determination made in this proceeding applies only to the South Carolina allocable share of the additional pre-construction costs of $75 million without AFUDC, not to exceed $120 million with AFUDC for the period of January 1, 2011 through June 30, 2012. Do you see that language?
I do see that language.
And does that refresh your recollection as to what the commission ordered?
There was also various other dockets during this, so that is what they ordered in that docket, yes.
Yes, ma'am. And as a part of that order, you would recall that the commission required Duke to file a quarterly report on expenditures in AFUDC. You recall that, don't you?
Yes, we do file quarterly reports.
All right. And you understand that you would have filed a quarterly report for the period ending June 30, 2012, do you not?
Yes, that would be reasonable.
Now, Ms. Smith, I've showed you a document labeled before the Public Service Commission of South Carolina, docket number 2011-20E. Do you see that document?
Yes, I do.
Have you had a chance to take a look at it?
Well, take a moment, yes.
Please, feel free.
Okay. Okay.
Let me draw your attention. Let me draw your attention to the second page of that document filed with the Public Service Commission, and draw your attention to the next to the bottom line that reads AFUDC. Do you see that on the far left?
Yes, I do.
And if I correctly understand the document, immediately to the right of that acronym AFUDC, is the number roughly $23.7 million. Do you see that?
I do see that.
And according to the Duke filing, that would be the AFUDC accumulated for the period 1/1/2011 through 12/31/2012. Would that be correct?
Actually, it says 3/31/2012.
Thank you, 3/31. And to the right of that number is a number about $5.5 million, correct?
Yes.
And correct me if I'm wrong, that number represents the quarterly AFUDC for the period 4/1/2012 through 6/30/2012, correct?
Yes.
All right, and continuing to the right, there's a number, $29,201,000. Do you see that?
Yes, that's correct.
And that's for that's the total for the period 1/1/2011 through 6/30/2012. Do you see that?
Yes, I do.
And would you disagree with me if I suggest to you that that number is the amount of the AFUDC accumulated pursuant to order number 2011-454 in docket number 2011-20-E? Would you disagree with my statement?
The one paragraph you showed me, yes.
All right. And then the last number of AFUDC is roughly $68 million. Do you see that?
Yes.
And that's the total AFUDC from the inception of the Lee nuclear project to 6/30/2012, correct?
Yes.
All right. Now, drawing your attention back to Mr. Fallon's testimony in his chart, from the period system-wide, from the period 6/30/2012 through roughly the date of this hearing, the AFUDC accumulated from about $68 million to $248 million system-wide, correct?
Yes, that is true, and we stopped AFUDC on 12/31/2017.
Good, thank you. So that $248 million number is through 12/31/2017?
Yes.
So it would have accumulated from July 1, 2012 through the 2017 date, correct?
Yes, sir.
Now, you understand that pursuant to order number 2011-454, at least the consequence of that order was that Duke was authorized system-wide to recover about $350 million in pre-construction costs associated with the Lee nuclear plant, correct?
I think we're getting into a legal conclusion again. I mean, we're not objecting to what the order said. It can speak for itself, but what the legal conclusion is beyond the scope of that witness, of this witness.
Yes, the order will speak for itself.
Very fine, thank you. And but you do understand that from the period of the inception of the Lee nuclear plant through 6/30/2012, whatever you were authorized, Duke only spent about $251 million in pre-construction costs. You understand that to be the case, don't you?
And that is listed on here, correct?
That would not be listed on there. No, ma'am. I thought since you were the rates woman,
Well,
know that.
that's
the rates witness.
and that was what, 2012. So that's, I don't know it by year on how much we've spent.
All right.
I mean, that's,
That's fine. All right, let me understand from your testimony, please, and I draw your attention, if I may, to pages 19 and 20 of your direct. As I understand it, Duke is seeking to recover $518 million total from the Lee nuclear pre-construction cost. Am I correct? I have a little confusion, so.
We're asking for recovery of $125 million.
All right, for South Carolina. And what's system-wide?
The system-wide is approximately 4 times that.
Okay. The reason I ask is in Mr. Fallon's chart, it shows a total pre-construction cost of $559 million. Do you see that?
Yes, I do.
And I think I understand that some of the land and right-of-way costs may not be recoverable pursuant to the pre-construction cost, that there's some aspect of that doesn't go under rate base, and that as a consequence, the total system number is $518 million.
Yeah.
Am I?
Yeah, we have removed the land held for future use and put it in rate base. Plus, we removed the cost related to the visitor center.
Good. And so would that reduce the total on Mr. Fallon's chart from 559 to 518?
Let me check my, it's in my pro forma, but yes. It's approximately correct.
Okay. That's all I'm asking.
Okay.
I'm trying to make sure I have it straight. Now, directly to your testimony on page 19 at line 20, this is where you introduced to the commission the $25 million Lee nuclear pre-construction cost ask for South Carolina.
Yes.
All right. And then your testimony goes on to say that the annual revenue requirement in this proceeding is $20 million. Am I correct?
That is true.
Now, if the total Lee nuclear pre-construction costs are roughly $518, then it's fair to say that almost half of that total cost is the AFUDC you're seeking recovery of. Is that correct?
That is true, yes.
And so if you're seeking $20 million here, and as of the $20 million, I think $11 million are the capital costs, as the Base Load Review Act would call them, of the pre-construction costs that you're seeking recovery of, correct?
Yes.
All right. So you're asking for 20, 11 are the capital costs. And so of the $11 million a year you're asking the customers to pay, about half of that number would be the financing costs over the 12-year life of the project, correct?
Correct.
Now, turning to page 20, as I understand it, the balance of the $20 million annual cost $9 million is the net of tax return on the amount you're seeking recovery of. Is that correct?
Excuse me, can you ask that again?
Well, it was a bad question, but if you look at bottom of page 19,
okay,
top of page 20.
All right.
I'm doing no more than simply asking very inartfully for you to say what you said much more artfully on those lines. Basically, $11 million of the 20 are the capital costs, and $9 million is the return.
That is true, yes.
All right. And of that return, that's not all pure profit to Duke, is it?
No, it is not profit.
But wouldn't it be fair to say that approximately $6 million of that, based on your capital structure, would be what at least your ratepayers would consider profit?
No, I do not agree with that.
How much is profit?
It is not profit. We are not currently recovering these costs and rates from our customers. So since we're not recovering these costs and we have incurred these costs are being advanced by our investors, our debt and equity investors. And so it is a cost we have incurred, and shareholders and debt investors have advanced these costs to the company to incur. And so it is when they advance cost us, they expect a return. So it's not a profit.
Would it be fair to say that of the $9 million, about $3 million is associated with debt?
Yes, probably, yeah.
And would it be fair to say then that of the $9 million, $6 million is associated with equity?
Yes.
Mr. Chairman, thank you. I have no further questions.
Thank you. Walmart.
Good morning. My name is Carrie Grumman here on behalf of Walmart. My questions are for Mr. Gartetago, and they.
Is your microphone on? I just want to make sure. Is that red light on it?
I will speak closer to it.
There you go. You can bend it towards you if you need.
Mr. Gartetago, my questions relate primarily to a sentence that was contained in your opening statement this morning. I'll read it aloud so that we're both talking about the same thing, but it's the underlined sentence that says, we have shown that the company's proposed return on equity is in line with other ROEs determined by other regulatory commissions in the Southeast. I'd like to understand what you are relying on when you make that sentence, when the conclusion in that sentence.
I would refer you to the testimonies of Jack Sullivan as well as Mr. Hevert. They both refer, I believe Jack Sullivan's contains a table in there showing commission decisions from various states in the Southeast. It includes Mississippi, it includes Florida, it includes South Carolina and North Carolina. And I believe since 2013 until now, a range of about 9.85% to I think it's been 10.5 or so has been approved by commissions, with an average of about 10.19%. That's what I'm relying on.
Is this the chart to which you were just referring?
Yes.
And in looking at this chart, would you agree with me that if we accept every one of the returns listed there, that the average of those returns is 10.19%?
Yes.
And that is actually 1 basis point below your currently authorized return, yes?
Correct.
And 31 points below the return that you've proposed in these proceedings.
Yes.
And I want to direct your attention to the 2 entries listed there from 2018 in your proceedings before the North Carolina Commission. You recognize that you all were awarded a 9.9% ROE in the North Carolina proceedings, yes?
I agreed. We settled on that, and the commission approved the settlement.
Do you believe that the 10.5% ROE proposed in these proceedings is, as you described in your opening statement, in line with the ROE awarded in North Carolina?
Well, that's not what I said there. I said by commissions in the Southeast.
Which would include the decisions in North Carolina, is that
Exactly.
correct? That were awarded most recently last year.
Yes.
And I think that you told me a minute ago that you base this sentence not only on the testimony from Mr. Sullivan in the chart that we just looked at, but that we also looked at, that you also based that upon testimony from your expert witness, Mr. Hevert. Is that correct?
That's correct.
And you understand that in making his analysis, Mr. Hevert selected a proxy group of companies. Are you aware?
I am.
And do you have any understanding as we sit here today as to whether any of those companies in his proxy group of companies were located in the southeastern part of the United States?
I don't recall the specifics of that, but I'm sure he'll be able to tell you. Yes.
Would you just take a look through that list of proxy group companies and identify for me whether any of those companies are located within the southeastern portion of the United States?
I would say third from the bottom, Southern Company, that is in the southeastern part of the U.S. They're headquartered in Atlanta, Georgia, I believe. That is in the southeast.
Any other companies?
NextEra Energy would be from Florida.
Any other companies?
AEP is in Virginia.
AEP was not among the southeastern companies that were identified by Mr. Sullivan, were they?
No.
And actually, AEP Company Inc. is the parent company of the APCO Virginia entity, isn't that correct?
That's correct.
That would include their operations in West Virginia, Ohio, Kentucky, among others.
That's correct.
So in terms of your testimony in this proceeding as to the ROE, you undertook no effort to ensure that Mr. Hevert's proxy group analysis incorporated returns for southeastern utilities. Isn't that fair?
Well, I think the chart you just displayed shows a number of southeastern companies. That's his proxy group.
This is the proxy group, correct?
Correct.
Of the companies identified in the southeastern U.S. here in Mr. Sullivan, were any of these entities included in Mr. Hevert's proxy group?
So Georgia Power is a subsidiary of Southern Company. That's the first one listed. Florida Power and Light is a subsidiary of NextEra, which was in the proxy group listed.
Any other companies?
I believe Gulf Power is now owned by NextEra. And I think that would be it.
Based upon your opening statement and your testimony on ROE and the testimony from your witnesses, Mr. Hevert and Mr. Sullivan, are you asking this commission to accept the 10.5% from Mr. Hevert, or are you asking this commission to look at the average ROE for utilities in the Southeast when determining what an appropriate ROE in these proceedings would be?
We're asking the commission, based on the expert testimony of Mr. Hevert, to accept the 10.5%. His testimony supports 10.75%. In an effort to moderate the ask or the increase that we requested in this case, we built the case on 10.5%, and that's what we're asking the commission to accept.
And you feel comfortable that since your last rate case, circumstances have changed sufficiently that at least a 31% increase in your return on equity is justified here?
I believe the testimony we filed in North Carolina supported a similar ask, and yes, we believe that's justified.
And as you make that statement, do you factor in at all, I have pulled here page 15 of the rebuttal testimony of Mr. Hevert, but I think similar numbers were set forth in the testimony from Walmart witness Greg Tillman regarding average ROEs awarded within the United States. And I believe Mr. Hevert's testimony here summarizes it fairly, but I think the numbers we see range somewhere below 9.8% for any year going back as far as 2014. Would you agree with that?
That's what I see on that page, yes. But again, when it comes to, and Mr. Hevert will be able to explain this in great detail, but when it comes to the determination of a return on equity, it's not a question of just taking averages. There are various methodologies that are used. Some witnesses use the CAPM method and so forth. And he supports what we've asked for in great detail. And I would encourage you to ask him those questions.
Oh, I absolutely intend to ask Mr. Hevert questions. I simply am attempting to understand upon what you based your conclusion in your opening statement that the company's ROE is consistent with the ROEs by other regulatory commissions in the Southeast when the data I'm looking at shows a 10.19% ROE.
Okay.
I don't have any other questions.
Thank you. We're going to take a short break. We're going to, when we come back, we'll continue with ORS and commissioners. We'll break for lunch about 12:30. And then after we come back from lunch, we will finish at 4:30 this afternoon. Just wanted to let y'all know my schedule. So with that, we'll take a short break. Thank you. Bye.
down, you'll be starting. I think people would like to know for planning purposes.
Okay, it was asked tomorrow. We'll start tomorrow at 10 o'clock. What we originally planned was we'd see how far we get tomorrow, and by tomorrow afternoon we'll make a decision on first part of next week is if we need to start a little sooner or what. Sort of depends on you. So, ORS.
Thank you, Mr. Chairman. Mr. Garrity, to go, I'm going to start with you, Ms. Smith. I promise I won't leave you out. Ms. Garrity, to go, as part of your function as the president of the South Carolina, Duke, South Carolina, you attended the night hearings in this case, isn't that true?
I did.
Okay, and I'm sure you heard the comments from a lot of the ratepayers that we heard. I think over 150 people spoke that some of them are having a difficult time being able to pay their current rates, let alone looking at an increase, right?
I agree. I heard that.
But at the same time, Duke is still, you are still asking in this case for customers to pay for items such as team lunches, decorations for office celebrations, and employee coffee. Isn't that true?
Yes.
Okay. Do you think that it's fair that you continue to these people that can't afford their bills now pay for coffee for your employees?
I think it's important that customers, we compete for talent, much like any other company. And to provide cost-effective, reliable, safe electricity, you need qualified, very good employees. And so sometimes we spend money on things that include things that improve employee engagement, things that increase effectiveness of employees. And so those are some of the costs you're referring to here. And I think it's important to provide some of these things because when employees can get something better down the road, they will go down the road. So we have to be competitive in the marketplace for talent.
Well, you kind of had an option on these things as to whether the ratepayers pay for it or whether the shareholders pay for it, right?
Certainly, every cost item we have, you could say, but as you know, the precedent or the Supreme Court has said, on the one hand, you're balancing reasonableness of rates. On the other hand, the utility getting a fair return on its investment devoted to the public use.
Has the company considered at all the impact, and especially based on the customer comments about difficulty paying, how this may affect the bad debt or the uncollectibles of the company? Have you considered that?
I'm not sure I understand the question.
Sure. If so many people are saying they can't afford to pay their power bills, isn't that going to drastically increase, or won't that show an increase in the company's uncollectibles? It
could, yes.
Okay. And then therefore that would then be paid by the other customers, correct? The uncollectibles?
Yes.
Yeah. Does Duke have any kind of a low-income assistance fund to help some low-income or elderly customers?
I mentioned earlier our Share the Warmth program, which includes funding from our foundation, includes contributions from other customers, contributions from employees. Those funds typically are distributed to agencies around our service territory. I believe in the Anderson hearing, you heard from Christy Brock, who heads up the Anderson Interfaith Ministries, AIM, and she talked about some of the funding we provide to her agency so that they can, in turn, provide it to customers who are unable to pay their bills.
So you don't do it directly, but you do it indirectly through these other organizations, is
exactly.
That what you're saying? Okay. How long do you think it's going to be before the company comes in to ask for another rate increase?
I can't say sitting here, and I think the outcome of this case could also be a factor.
Does the change in your position on the base facility charge in some way affect that you might be in sooner with this low base facility?
I don't believe so.
We heard a lot of complaints at the night hearings, too, about customer service, and there seemed to be a disconnect a lot of times with what people call in with and who's sent out to do work. Has the company done anything since those night hearings, or have you started a process at all to try and correct those problems that were identified?
See, and I think the value of the night hearings is to give customers an opportunity to speak to the commission about their individual situations. I will say there were, as you said, about 150 speakers. We have over 591,000 accounts in the upstate, right? I will say there were a small fraction of the 150 who spoke can't raise the issue you just described in terms of a disconnect between what they call the call center with, and those things can happen. I will tell you, I get letters, I get calls from customers about issues like that or other issues. And typically the way I handle it is I identify, I've got someone who's dedicated to customer service on my team who investigates it. And to the extent that there is an operational deficiency, we correct it. To the extent that it was a miscommunication, sometimes that's what it is, a miscommunication between the customer and the call center representative, and we fix that. So those things do happen or have happened, and when they do, we fix it.
I want to ask you about the AMI meters, too, because that was another issue that was discussed at length. And we heard from a lot of customers that they actually thought their bills had doubled as a result of these AMI meters being installed. Is that a recurring problem that the company has identified, or could you just address that issue?
Yes, thank you for the opportunity to address it, because there was one who alleged that his bill had gone from $400 to $900. Thankfully, we got his name. We pulled up his record, and in the last 18 months or so since this meter was installed, there was no bill for $900 on his record. You know, so sometimes I do think, you know, I think they just want to make a point and they throw out numbers. But we have not gotten many complaints of bills doubling. I have an AMI meter on my home, and I can assure you my bill has not doubled.
Have you, and I guess as a part of the process of installing these meters all along, was there coordination made, or did you check with other electric utilities throughout the country as far as what impact these meters may have had on their customers' rates?
We did reach out to other utilities on the process in terms of how we engage with customers before we roll it out, the continuing education of customers as we roll it out. So yes, we learned lessons from other utilities when we did this.
I want to talk for a minute about incentive pay and bonuses. Are any of these tied to actual customer service numbers like J.D. Power numbers?
Yes.
Okay, and what percentage or for who are those typically tied to?
Well, so I believe every employee has a short-term incentive opportunity, and the opportunity is tied to metrics such as you say, customer service based on J.D. Power scores, such as safety, such as operational excellence, and then earnings per share. Yes.
All right. Thank you, sir. You mentioned, and I forget who asked this question before, but you talked about 2 excavations in South Carolina of coal ash ponds. Is that correct?
That's correct.
That was due to a DHEC consent order as opposed to a state law. Isn't that correct?
Yes, but DHEC is a state agency charged with enforcing environmental regulations and the environmental policy of the state.
Why did the company decide to go to a 10.5 ROE if your experts said you're entitled to a 10.75?
Because we thought that certainly in recognizing some of the issues the employees discussed in the public hearing, we wanted to mitigate what we asked for in this case, and that's one of the ways that we did that.
You actually asked for that in the application, though, didn't you?
Yes.
Which was before the night hearings, correct?
Exactly, but I'm saying even before we filed the application, we were very conscious of the impact of increasing or raising rates on customers.
So it's not the fact that you feel that 10.75 is out of line with any current ROE awards?
No, I believe 10.75 is justified by the testimony that we've supplied in this case.
Ms. Smith, I'm going to turn to you now, if I could, please. I want to talk about the deferrals, because that seems to be one of the, one of the bigger issues, I guess, that we've still got out there. 5 of these 6 deferrals, ORS isn't actually contesting the amount of the deferral, but just a return on that deferral. Is that correct?
That is true.
Okay. So, and the 6th one is the coal ash, correct?
Yes.
Okay. So the issue that we're really talking about here is just that return. And do you have an idea, could you tell me what amount of money we're talking about between the ORS position and the Duke position?
About $68 million.
Okay. Is it also true that expenses in the deferral balances you're seeking to recover include both operational related costs and capital related costs?
The costs that we are requesting to recover, I don't break them out into capital-based cost versus operating expense cost. We are asking to defer cost, and those costs include the return on the capital, the property taxes, O&M, and depreciation. So normally, interest expense return is also an operating expense. And all four of those cost categories we're asking to recover are all related to the capital, or to the, to the capital project, or the capital as you all say it. So we don't normally think of that, breaking it out into capital related and O&M related, but I would think they're all related to the capital. We wouldn't have the property expense if we didn't have the capital.
But like your O&M expenses you just mentioned, those operational and maintenance expenses are operating expenses, aren't they? That's typical operating expense for the company.
So is interest expense. Yes, sir. Okay.
Under what accounting principle or theory is Duke making the claim that they are entitled to a return on a deferral of operating costs?
Deferrals are a regulatory mechanism, and we come to the commission and ask for a deferral when we are incurring costs that we are not currently recovering from our customers. That's why we come and ask for a deferral. And by definition, if we are not recovering those costs from our customers during that time period, then our investors, debt and equity investors, are advancing those funds to the company. And normally when an investor advances funds to a company, they expect a reasonable rate of return. So that's what we're asking for, is a reasonable rate of return on these deferrals.
But typically when this commission and when other commissions set rates, and we go on a historical test year, correct?
Yes.
And so operational and maintenance costs just captured during that test year, except for extraordinary expenses, are what is included in the calculation of rates, right?
Yes, there are some adjustments.
There are some adjustments, I agree, but generally we're talking about just actual O&M expenses during the test year, correct?
With some adjustments,
okay.
Yes.
All right. I'm good at that.
Yes.
Coal ash costs, coal ash costs seem to be extraordinary. I mean, that obviously what you're doing here isn't typical or what's been done in the past, but of the other 5 of those 6 deferrals, can you say that there's anything extraordinary about those costs, or are those just the normal costs of doing business for Duke?
There were costs that we were not currently incurring from our customers, and the word extraordinary, I'm not sure where that came from in the context of deferrals. So.
The company determines when it files a rate case, correct?
Yes, it does.
Okay. And the company also has the option, it's their choice to pick a particular test year too, correct?
Yes.
Okay. So you're also, Duke also appears to be claiming in this case then that you're permitted to not only charge ratepayers for non-test year expenses, but also to earn a return on those expenses. You got the test year, 2017 in this case, right?
Yes.
You're throwing these other costs in, and you want to get a return on that. You don't get a return on the O&M costs during the test year, do you?
Let me go back. So a deferral is one mechanism in a wide range of mechanisms for a commission to allow a company to earn its operating expenses plus a reasonable return for its investors. Yes, we do use a test year, which we do update, but the deferral helps us, and we do delay rate cases with regard to deferrals. But some states use other mechanisms, if you're in a state that allows step-up rates, you may not need deferrals as often. Or if you're in a state that uses a projected test period and not a historical test period, then you may not come in for deferrals as often. But when you have a historical test period that's only adjusted for a certain amount, you can only adjust it a certain amount, then there are costs, since we are not recovering it from our customers, and we think they are prudent costs to incur at that time, then the investors advance us that money. So it's not as much the fact that that those costs are not in our test year. It's just the investors have advanced us cash, and we are asking for a return on the cash that the investors have invested in the company.
In this whole process, I've heard a lot of times y'all talking about the fact that this all helps your investors. Investors expect a return. Isn't this commission supposed to balance both the interest of the investor as well as the interest of the ratepayer?
Well, yes, but it's a reasonable return, and currently we don't have a reasonable return. And actually, the ORS witness Purcell says a reasonable return is 9.3%, and our witness Hebert is 10.75%. So unless the investors are earning that return currently, then they're not earning a reasonable return in the ORS witness nor DEC's witness.
But ORS isn't contesting the fact that you're entitled to the amount in those deferrals again, are they? We're only contesting whether or not you're entitled to a return to your investors on those deferrals, correct?
Okay, well, let's look at it this way. It's like when you go to the bank. You go to the bank, you're going to build a new building, you're a business. And it's going to, but you need to spend, it's prudently spent. You have to serve your customers, you need a new building. So you go to the bank and you're like, oh, I need to borrow some money, construction loan, I'm going to build a new store, some inventory, etc., hire employees. I would like you to lend me the money. So the bank lends them the money, and that is cash out the door. The bank's going to expect interest back, and they're going to expect that interest on that cash they advanced that business, no matter what the cash was used for. So we have financing cost, whether the cash was used for what you all term as operating expense or capital-related expense. But it's all cash out the door to the investors.
And I'll agree with all of that, except Duke Energy Carolinas isn't a bank, is it? You're a public utility.
No, but we have investors, and they expect a reasonable return.
No further questions. Thank you both. Thank you, Mr. Chair.
Thank you. Okay, commissioners, questions. Commissioner Howard.
Good morning, both of you. Kate, I was curious, you were at all 3 night hearings.
I was, yes.
And I guess, and in particular, the night hearing in Anderson, you sat by a young lady named Ann Gaffunda.
Yes.
And I think her story was probably one of the saddest I've heard, in my opinion.
Yes.
But she had a light bill of something like $36 a month. She had allocated to pay for her electricity. And at that point in time, we were talking about a $28 basic facility charge. Now that's reduced. But tell me what your take was. Did you have a conversation with her? She sat by you, she said, and I know she did. But did you have a conversation with her, or what was your take on her situation versus other low-income people's situations?
Like you, I was very much struck and touched by her story. She has a son. She told me a lot about her personal life and the challenges she faces. She's also got a medical condition that's got her on disability. So she has limited income as well. And I was very touched by her story, and certainly recognized that in that case, somebody with such low usage, in fact, I think she commented on while she testified, and it is true that I said I had never seen such low bills, because I think her monthly usage was probably 248 or so kilowatt hours. And she pulled it up. I showed her how she could pull it up on our app. She didn't have the app, so she went to the website, pulled it, and showed it to me. So I was very struck by that. Yes, you know, for somebody like that with such low bills, an increase in the basic facilities charge absolutely adversely impacts them to the extent they cannot afford to pay. Yes.
What could or what does Duke do to help these people? What kind of low-income assistance do you have, a program you have available? I'm not talking about the social programs from other agencies. I'm talking about Duke Corporation itself.
So we have our Neighborhood Energy Saver program, for example, where we go into typically lower income neighborhoods with folks who do energy audits, determine improvements that can be made to the home, such as changing out light bulbs, such as recommending insulation additions. We even look at water flow, give them new shower heads and so forth, all with a goal of reducing the usage of electricity or water in the case of the shower heads, and ultimately reducing their costs. That's one. We also have a program where if you're not in one of these neighborhoods or you live in an apartment, you can actually call in. We'll come and do an audit individually at no cost to you and make some recommendations to you. We'll also leave you a kit that you can self-install. I've also mentioned the Share the Warmth program a couple of times already today. We can refer you to those kinds of programs for assistance. We can also work with you if you have trouble paying your bill on a payment plan, for example. So we have those different initiatives that could be beneficial to low-income customers.
Two things, and I know it's done in the water industry a good bit or somewhat, but roundups. Have you considered a roundup program, and what's your mindset or what's Duke's opinion of a roundup program?
So after we filed our rate case, one of the things I did do was reach out to various stakeholders. One of the ones I reached out to was AIM and Krista Brock, who spoke at the Anderson hearing too. And she suggested roundup when she spoke. She had actually spoken to me about it before, so it's something I've been thinking about. I think it would be beneficial. Much like the Share the Warmth, where we encourage our customers to donate to a fund that ultimately gets shared to lower income customers to assist them with their payments. Roundup is an opportunity for customers to, I don't know if folks know how it works, but essentially if your bill is $10.50, you can opt to round it up to $11, and then the 50 cents gets added to a fund that ultimately could be, I don't think Duke would administer it, but we would use agencies like AIM to administer it, so that could be an additional source of funds to help others. I am very interested.
Two things about it. Number one, it's voluntary.
Yes.
It has to be voluntary. And number two, a third party has to administer it.
Yes. Yes. And so I've got our team looking at that. We don't have the systems to implement it now. But I've told the team that's something I absolutely want to implement. So we're looking at it internally, and as soon as we're ready to, we will propose something to the Commission.
Do you have any idea of how much additional income this fund could generate? I mean, this roundup could generate the low-income fund?
I do not. I do not. But part of the work we do is trying to identify the utilities who do it, and we would have to find utilities probably with the same customer base like ours to see how much they generate. But I do not know how much it would.
What about prepay?
So we have a prepay program, and in this case, we're recommending that we make it available to everyone. We've had a pilot for the last few years, and in this case, we're recommending that it becomes available to everyone. But that would be another option, you're right, because in that case, we would not need a deposit from the customer, because typically lower income customers also do have a difficulty or a challenge paying deposits. But with prepay, you can better control your usage and better control how much you spend on electricity. And we have found through the pilot program, our customers are very satisfied with it.
I should know this, and I guess I do, but do you own your advanced meter, and do you have an opt-out provision?
Yes, we do.
What percentage do your customers take advantage of the opt-out?
Very.
I'm talking about rough. I don't.
Yeah, very, very small percentage. I believe it's less than 2%.
That takes advantage of the opt-out?
Yes.
Are they well aware of it? I mean, is it advertised enough to know that they have that option, or they just assumed when you put an advanced meter in, that's how they got to go?
I don't know that we advertise that there's opt-out available. It's a schedule that has been approved by the Commission. And so when we do go into a home and they say they don't want it, then we offer them that option.
On your rate of return, you mentioned a 10.5, but you also mentioned it came in at 10.75. what was the complete range? What was the low number on that range? Was the low number 10.5, or when your return of it, the ROE expert gave you a range of ROEs, what was the low number?
Usually the range, and I think I'll defer to Mr. Heverett on that one, but usually the range is about 100 basis points, and the 10.75 would be sort of the middle of the range. So 10.5 probably is the bottom of the range.
There was a lower range.
Yes.
In a basic facility charge, what are some of the risks that your company and your industry takes to utilize to mitigate different things in the industry, different risks, different things in the industry that you would utilize your basic facility charge to help mitigate? Other than what you have mentioned, you understand the question?
I'm not sure I do.
The basic facility charge is a fixed charge that you could use to help offset any other cost.
Yes.
Yes, that was my question. What costs that you occur that you would consider the base facility charge, taking care of or help mitigating those costs?
Yes, the basic facilities charge is intended to cover the cost to make electricity available to the customer. Some utilities call it a service charge, some call it an availability charge, but it's intended to capture the fixed costs that do not vary with usage to serve the customer. And we originally proposed something that was less than $1 a day. We have since accepted ORS witness proposal of $11.96, which is about 40 cents a day to have electricity available to the customer.
Well, then, let me follow up. How do you respond to customers or people who complain that the use of a basic facility charge would eliminate or curtail, offset their use of energy efficiency programs or conservation programs? We heard that a lot at the night hearings. I'm sure you did too.
I did too. Well, to the extent that the energy efficiency programs or even installation of solar sort of reduces your usage, your cost that is calculated based on usage is lowered as you implement energy efficiency and as you install solar. So to the extent that we shift costs from the variable rate to the fixed charge, it will show lower savings. That is true. But I would say those savings probably shouldn't have been true savings if the basic facilities charge is not an accurate representation of the fixed charge.
Okay, thank you. Mr. Smith.
Yes.
Talk about your PP&E program, your EDIC, I think you call it, EDIC?
Yes, the tax give back. Yes, sir.
All right.
Yes.
Tell me about that, and tell me about, you're asking for a 20-year payback on the unprotected?
Yes, on the unprotected.
How much up front? How much money is in that group? How long have you been collecting that fund, and how?
Oh, how long we've been collecting it. I do not know how long we've been collecting it. It's a tax entry that's made every year. But the unprotected is basically based on property. It's just not the type of property that is considered protected. So it probably is over a longer period of time. But the exact years, I do not know. But I can get you an answer to that if you'd like it. I think.
Well, I don't know that I'd understand, to be honest with you.
These taxes are very, I thought the tax law was going to make everything simpler, but I'm not too sure about that.
Well, tell me you had some other assets, and I think other assets in your non-protected, well, other assets, yes, plants and all those are in the protected assets. Your non-protected assets, you mentioned one thing with regulatory liabilities. What are some other things that would be categorized in the non-protected?
The whole regulatory liability of these deferred taxes are all related to a tax impact of some type, whether it's a deferred, like on the, when you buy equipment, you have bonus depreciation. So that creates we owe taxes, but due to bonus depreciation, those taxes will be later, because bonus depreciation is only used for tax purposes. So, for example, if you have a asset and it's got a 20-year life, 20-year depreciation, for tax purposes, we could speed up that. Let's say take the whole thing, 100% the first year. Well, that delays the payment of taxes. So we put the regulatory liability on the books because eventually we're going to have to pay those taxes. Just not right now because the tax law allowed us to take bonus depreciation. So that is one category. So it's basically timing differences between when the tax is incurred or the cost is incurred and we have to pay the taxes. Is what causes all the different tax liabilities, or sometimes you have a tax asset. You can have either.
Thank both of you very much. Appreciate your answers.
Thank you. Commissioner Belzer.
Good morning.
Good morning.
Morning.
Let's see. I've got so many notes written here. Ms. Smith, I'm going to start with you if you don't mind.
Okay.
Let's on page 23 of your direct testimony, you referenced the North Carolina Commission's order. On lines 3 through 6, you stated the North Carolina Utilities Commission approved the company's request to cancel the Lee nuclear project and permitted recovery of the North Carolina allocable share to the company's investment in the Lee nuclear project with some limited exceptions. Did I read that correctly?
Yes.
What exceptions were those that the commission listed? Do you know?
Yes, we did not recover the cost of the visitor center that we were building, and I think that was it, the visitor center, and we did not get a return on the amortization period.
So plural exceptions, there are only 2?
Yes. Oh, and yes, that's true. Oh, and the non-depreciable land cost we removed.
Okay.
We removed those ahead of time.
Okay. And I think you discussed that with Mr. Elliott, is that correct?
Yes.
Are you, I think Mr. Gardy Tago talked about the prepay. Are you familiar with that program?
Actually, I am very familiar with prepaid. A prior job.
Okay. We heard some discussion about getting a return on deferrals. But if y'all have customers that are prepaying, and I understand that it's something that might be started, is there going to be interest accruing on those customers' funds that need to be credited somehow?
Actually, I think the majority of the customers that are going to use the prepaid account are going to use it like they set up what we're expecting. I'm not sure if this is what is occurring or not, but it'll be more likely low-income customers who can only pay like $50 at a time. So they'll put $50 on it and then use that $50 worth. And then
so it allows them to like just pay maybe twice a month or 3 times a month.
Yeah, 3 times a month.
One bill in arrears.
Yeah, and I think too, I was in the customer world for a while. I think a lot of customers, to go out and borrow from a neighbor a $200 deposit is very hard, but they might be able to go out and borrow $50 to put on their prepaid account. So I think it really helps the low-income customers. I don't think people would be putting large amounts on it.
Okay. I just hear customer money coming in from the customers, and I'm trying to figure out what's going on.
Now, we do pay money on our deposits.
Well, that's required.
Yes, it is required, but it is done, so.
I think that's it right now. I may come back to you, though.
Okay.
Mr. Gardy Toga, it's good to see you this morning.
See you too.
Thank you. I did see you at the night hearings, and I have some questions, too, about the smart meters. And if you are not the appropriate person to answer those, I'd appreciate you letting me know who can discuss those with me, if you don't mind. Okay. First of all, there were well, I say a number, but for a night hearing, several people that complained about the AMI meters. And you mentioned checking the bill of the one gentleman with that indicated the 900. Did y'all check on any of the other customers that indicated that their bills had increased substantially after the installation of the smart meter?
I don't know if we checked all of them, but there were, as you know, we had a team in the room, and customers who wanted to engage with us, we engaged with. And if they had billing questions, we had somebody on the spot who could check that. But I have not verified that every one of them was checked.
You don't have any results of any of those conversations today?
I do not, except for that one case that seemed pretty egregious. So.
There were a couple of people that indicated that installations may have been faulty. Do you know if y'all have followed up on those?
Yeah, so the one I did follow up on, and which I mentioned before, I think he made one of those. That was one of his complaints, and we did check on that. As I recall, there was an issue, an electrical issue, that caused his, he said, his strip heat to come on, but I think the heat pump ended up going into auxiliary heat. So it was an electrical issue. I'm not sure it was directly as a result of the AMI meter being installed, but it was an electrical issue at the home that caused that to happen.
I'm not familiar with the operations of these meters, but is there a factor that has to be coded into the meter as far as reading and calculating usage? I'm just wondering if there could be a factor input that might have created some issues with billing.
I do not know that, but I doubt it. I mean, I think, you know, the regulations allow customers to request meters to be tested, I believe, once a year. And so I think there are some who've called and we've come out and tested their meters. Okay. I don't think there's any adjustment factor in the meter itself, but I don't know if we have any witnesses remaining who can speak to that, but maybe counsel can help me there in terms of who the best witness might be.
Well, maybe I'll hear something later on. I can.
Yeah, I think Jay Oliver was excused.
And can I add, too, that there's also a meter testing program that the company has to go through every year, and we have to test so many of our meters, and they have to be within a certain parameter. And so these would fall under that testing. Plus, I think we understand they're all tested before they're put into.
Commissioner Howard asked you about the opt-out. Are customers notified far in advance that their meter is going to be changed out so that if they wanted to opt out, they could?
Yes.
And I believe that there is a monthly charge to those customers because you have to send a meter or somebody out to check the meter and they're not read remotely or however the smart meters are read.
Correct.
Let's talk just a second about the eliminating the charges for the credit cards or convenience fees.
Yes.
The company would still have to pay those fees. Is that correct?
Yes.
And how would the company collect the fees? Would it just be spread out over all the customers rather than just those customers?
Exactly. That's what we're proposing in this case.
Credit card or debit card? Okay.
All payment channels would be free.
What cost savings does the company experience from having more customers use credit cards?
We don't experience savings. We experience costs, which is what we're trying to.
Well, currently, when bills come in, somebody's got to get the mail. Somebody's got to open the mail. Somebody's got to process the check. If checks are bounced, there are going to be late fees and charges that somebody has to deal with on that. You got to run them down and get another, or put it back on the bill. But if somebody's paying by credit card, and you expect the numbers to increase potentially, do you not?
We do.
You don't have to worry about chasing somebody down for a late fee or anything. So are there not going to be some savings the more people you can shift over to credit cards?
Well, I can say.
I know we're talking 500,000 customer accounts here in South Carolina, but.
Yeah, and I'm not sure we'll get 100% adoption, at least not immediately. But we have not determined if there will be any savings.
Let's see. I think that's it right now. Thank y'all very much.
Thank you, Commissioner Belzer. Is that everything?
Yes, sir.
Okay. Okay, we're going to break for lunch, and we'll continue with commissioner questions. We'll be back at 1:38.